Welcome, everybody. Good afternoon and welcome. And thank you all for coming, especially right in the middle of the holiday season and during the middle of all of this snow. It's wonderful to be with all of you again and really working in concert with this group of people, the panelists today, and those of you who are here to be trained, working with you all together in this kind of semi-revolutionary work that we're pulling together. And thank you, as always, to Davis Wright Tremaine for bringing the effort and the technology to make these trainings happen. Without you, this is not happening. My special thanks once again goes out to Kellyanne Brophy, who puts up with me, and to the Davis Wright, the tech team and the CLE team. So thank you so much. Let's see, let us go. You've got that one up there, slide 1. Okay, great. Let's remind everybody briefly of what we talked about in session 1. So I talked about the issue, which is that there are individuals at risk of deportation because of old criminal convictions. And Sarah talked at length with you about the law that provides relief to many of these individuals. I do want to point one thing out that I've been realizing over the past several weeks. The kinds of cases that I have been talking about so far during these trainings and during the lunch and learn that we did back in the summer. And in fact, the only kinds of cases we have ever done to date are, in fact, cases in which the client was facing deportation that had a final order of removal. And we will have more of these kinds of cases. I am certain of that. But I realize that we will also be receiving cases from NERP, and we'll go over the flow chart of who does what in just a moment. But we will also be receiving cases in which the immigration consequences do not rise to the level yet of the client already having been issued a final order of removal. We may have cases in which we are trying to get rid of the conviction, the old conviction, before a final order of removal is issued, or where the client is already in removal proceedings, or in order to prevent other damaging immigration consequences arising out of an old defective conviction. Either way, the common thread of every conviction that you will be seeking to vacate is that the conviction was unconstitutionally obtained and that that conviction is affecting the client's immigration case in a negative way. So back to what we talked about in session 1, individuals with potentially defective convictions that are causing risk of deportation or other negative immigration consequences, and the law governing how to advocate for those clients. What we are going to talk about today is the process of actually doing the PCR, the post-conviction relief, in order to relieve the client of those ill-gotten consequences of the potentially defective convictions. I am going to talk really quickly. You don't have to go to the next slide quite yet over the agenda and the participants for today's training. I'm going to talk with you for somewhere under an hour about the actual process of seeking a vacate. And I'm going to do this by taking you through what we are calling a straightforward vacate case. So the kinds of cases that we've done so far. And along the way, we'll be talking about the materials that you will be using throughout the vacate process. Then you will hear from Neil Fox, who is here with us today, who is a pro at these kinds of cases. There he is. Thank you, Neil, a longtime criminal defense attorney here in our state. And then you will hear from two people you've heard from before, part of this project, Kevin Hollins, who's with NERP. He is an immigration attorney at NERP, and Sarah Hudson, the expert on the intersection of criminal law and immigration law at Washington Defender Association, or WDA. I want you, please, at any point that I'm talking and you would like me to stop, let's see, just turn your mic on and ask me a question. Don't hesitate to ask questions at any point during today's presentation. Okay, Sarah, can you go to slide 2? she's doing this for me because I can't, I honestly am so tech challenged. So thank you very much. Okay, there's the person. We're going to talk about the flow chart. I think you guys know this already because I have talked about it, but I just want to make sure everybody knows who's who and who is doing what throughout this process. And just make sure everybody knows what each group's role is. Okay, let's see here. So here's the client, and he's having a problem with an immigration consequence arising out of an old criminal conviction. So he goes to NERP. NERP is going to screen that client to determine if they can help them. NERP will obtain all the records that they need, the client's court records and immigration records. They'll order background checks, both state and federal. And your client's immigration lawyer at NERP will review all of these materials. NERP will then decide that, yes, the client will benefit from post-conviction relief. And when Kevin is talking later, he may, I'm sure he will expand on that. Okay, so then what happens next is NERP then refers the client over to me at SCP, Seattle Clemency Project, along with all of the documentation that they gathered. They will also send a referral form that they have filled out, and that is on our website, and you will have access to those. They will send a referral form that they have filled out, which lists all of the client's convictions, specifically highlighting which conviction or convictions need to be vacated, along with a brief summary of the client's background and equities. Then I, at SCP, now the client is with me. I will interview them to get them ready for handoff to the pro bono attorney, and that's you guys. When I have them, will interview them. I will draft a handoff memo, which will give you all of the client's information, all of the client's contact information, all of the immigration lawyer's contact information, a summary of the client's background and his family's background, description of the incident resulting in the conviction that you will be seeking to vacate, and the client's current situation and equities. Then I will hand the client to you, and you will do the post-conviction relief, the PCR. And you will be, as you can see, supported by WDA and Seattle Clemency Project the entire way. After you have secured, and we're going to go through that whole process in just a minute. After you have secured the PCR or the vacate, you will hand the client back to NERP, who will take the client back into immigration court to have their deportation order terminated or whatever immigration relief it is that they are seeking. So that is what each of the parties in this project does. So the main thing I want you to remember, it's probably not the last time I'll say this today, is that when the client comes to you, he's already coming with marching orders from an immigration lawyer. He's coming to you with all the materials that you will need. He will come to you with memos, referral memos, all of the documents that you will need. And I and Sarah at WDA will support you the entire way. I will give you the materials that you need, and Sarah will provide the legal advice. So the bottom line is you will be supported throughout. But there was a line that I just said, which is you will do the vacate, you will do the PCR, and that's what we're here to talk about today in this second training. I'm going to take you from start to finish through what I am calling, for lack of a better word, I'm calling it a straightforward vacate case, which are all of the cases that we've been lucky enough to do so far. Not every case will look like this. That's just a simple fact. Not every case will look like this. Each case will be different, but every case will contain a conviction which triggered negative immigration consequences, a conviction that you are out to show was defective. And to illustrate the process for you today, I'm going to use the cases that we've been doing in two cases in particular to provide this ground level primer of how the process works. Neil will take you more in depth about what the process looks like to a seasoned pro, and in cases that are probably not so straightforward. For instance, and you'll see this as we go, maybe the prosecutor will refuse to talk to you, much less enter into an agreed motion with you. Okay, let's take a look at slide 3. Thank you so much. Vacate manual. Okay, that's the main thing. So here's the great news. Along with having Sarah and the immigration lawyer and me with you along the way, you're going to have a vacate manual that holds your hand through the entire process. And here's the great news. We have drafted this vacate manual. It is not quite completely done. It is near completion, has everything it needs. We're just embedding the exhibits into it and finalizing it. And we didn't want more than one version floating around, so I did not include it in your materials today. We may have learned from experience not to have more than one version of a manual floating around. So this manual will be done really soon, and we will put that up on our website. But when I meet with you, of course, the manual is going to be something that I give to you. This manual literally takes you step by step through the process of seeking a vacate for your client, from meeting the client or meeting me, handing off the client, all the way up to the point where you attend the hearing. While I'm taking you through the process of a straightforward vacate, I'm going to use the manual as my guide. That's how good the manual is. Along the way, we'll talk about the manual's exhibits that you will be leaning on as you go through the process. And again, I have included many of those exhibits in your materials today. Okay, so as you can see, the main sections of the manual are the first thing you'll do, and I'm going to talk about these one at a time as we go through this this afternoon. The first thing you're going to do is meet with Seattle Clemency Project to learn about your client's case, and SCP provides you with documentation. The next thing you'll do is the next section of the manual is meet with the client and interview the client. The next section, gathering additional documentation, then preparing letter to the prosecutor, negotiating with the prosecutor, preparing the pleadings, and attending the hearing. Okay. I think we need to go to slide 4 now. Thank you. Okay. The first thing in the manual, the first step of the process will be to meet with SCP and learn about the case being assigned to you. And that's pretty straightforward, meet with SCP. Okay, you'll meet with Seattle Clemency Project. That will be probably me, and I will provide you with all the documentation that you will need to get started. Before COVID, which I am shocked when I was preparing for today to realize that it's been 3 years, I think, almost, since I handed off a client in person. We used to do a binder that was full of, there might be a few people here today who received one of those binders. It was, the handoff memo was on the top, then the criminal documents, then the immigration documents. But ever since COVID, we've been handing off the client electronically and all the materials. So that's probably what we'll do, is we'll do it virtually. And these are the materials that I'll be giving you. Honestly, I'm going to say the word manual probably 100 more times today, and I'm sorry about that, but for fear of, sorry, I'm going to give you the manual. I will also be giving you the handoff memo that I drafted, that I told you about earlier, with all the client's contact information and a summary. The referral memo from NERP, which we talked about earlier. Both of these documents, among many other things, will list the conviction or the convictions that need the post-conviction relief. I will also give you court documents and other documents that I was given by NERP, that NERP ordered, which will include, the court documents will include the judgment and sentence and the statement of defendant on plea of guilty. And I will also give you the watch report and the FBI report that NERP obtained. We will also be providing you with lots and lots of samples. So the samples that I will be giving you when I hand off the client will be sample letters to the prosecutor and sample pleadings that you will be drafting, which would include motions and orders, declarations of client, declarations of client's spouse or witness, declaration of client's original defense attorney, and declaration of crimmigration expert, as well as a new statement of defendant on plea of guilty. We will be talking about all these materials in just a couple of minutes. Slide number 5. Great. Your relationship, the next thing you're gonna do is meet with your client, and your relationship with your client, in the cases we have done, your relationship with your client will be the key to your advocacy. So your goal, of course, will be to get all of the information that you will need to show that your client's conviction was defective and that it affected their immigration case in a negative way. Remember that they will already have been screened by us, by NERP and SCP, and you will have quite a bit of information about them already from the handoff memo and the referral memo. But you will reach out to them, ultimately interviewing them to get what we call their life story and all the facts that you will need to advocate for your client, starting with what you will be doing would be writing the letter to the prosecutor. So you'll just be getting all of the information from your client that you will need to make your client's case. The manual literally gives you all of the topics you might want to cover while you are talking with the client, and then some. I think I may have gone overboard. I don't need to list them all here, that is for sure. It will be common sense to you. I think some of our lawyers don't probably even look at the manual because much of this is common sense. But the manual will list questions about the client's background, their family's background, circumstances leading up to their criminal activity, particularly the event that led to the conviction that you are seeking to vacate, what happened at the trial level with their defense attorney, and their current life and rehabilitation. And this is what I have found and what I have learned from almost all of the pro bono lawyers that we've trained and who have done this work. And that is that getting to know your client and getting to know your client's background and their family story is by far the best part of the job. I was actually just talking with a client yesterday that I thought I had just a couple things I wanted to talk with him about before I hand him off. He's a pardon client, actually, not a vacate client. And I had a couple of gaps I wanted to fill in with him. So I told him maybe 20 minutes if we could hop on the phone, and we ended up talking for 2 hours. He was talking. All of it is stuff that I needed or that his lawyer will need. And honestly, I mean, he had been kidnapped when he was a little kid. He had fled one war-torn country with his family in Africa when he was like 4 and lived in a refugee camp in another African country for over a decade until he came here when he was almost 15. He came to Minnesota in the middle of the fall, but it was snowing. We got to Minnesota from sub-Saharan Africa in November. And believe it or not, it was not until he came to Seattle that the bad things started happening in his life that we needed to help him with. Just an incredible person. The only reason I tell this story is just you sort of never know what you're going to get. And we're the lucky ones that we get to work with such interesting people who have traditionally been so underrepresented. Slide number 6. The next thing that the manual covers is, and going back to meeting your client, I mean, the manual will walk you through the documentation that you will need to have that you will want to talk to the client about an attorney-client agreement. It links you to an exhibit that is an attorney-client exhibit. So all of that will be covered in the manual. Okay, gathering additional information. That's the next subject in the manual. This is mostly common sense again. But after you've gotten to know your client and gotten all the information you need from them, this is largely just you ensuring that you have all the court and other records that you need and any other materials you need to prove your case and show your client's equity. So you'll figure that out, but the manual will help you identify what some of those documents might be. It may be that you don't need anything other than, I do think that the main thing from this section that you will need and that I will not be providing you with is that you will need to talk with your client's original defense attorney about what they remember from the client's criminal case. Sometimes the case was a long time ago. Sometimes it was more recent. But you need to talk to them because it's when the client was not properly advised of the immigration consequences of the conviction that they have a ripe case for PCR. So you need to determine that. And one of the ways to figure that out is, of course, talking to your client about what happened, but also talking to your client's original defense counsel about what happened. And as you can imagine, this can be a delicate conversation. This can be a tough issue to crack with defense attorneys at times, and understandably feeling like you're calling up to accuse them of doing a bad job or to accuse them of ineffective assistance of counsel. And I have seen attorneys react defensively and say, I always advised, they don't want to talk about it. The manual walks you through several different scenarios. So I have seen defense attorneys react that way, but even more than that, I've seen a lot of attorneys just jump right in with no problem and say, oh yes, yep, what year was that? Oh yeah, no, I wasn't advising in those days. I remember that case and I remember not advising, or I don't remember that case, but it was certainly my practice to, it wasn't my practice to advise back when, XYZ client was my client. So the manual will help guide you through this. You can tell them that you can have an honest conversation about it, that we have talked with scores of defense counsel under similar circumstances, and we know that it simply wasn't for many years common practice to advise. You say it wasn't you, defense counsel, who did a bad job. That's not what we're saying. It was the system that was not set up to advocate for non-citizen defendants. So that is part of what you will be doing under the section of the manual that is gathering additional information. And I think we all know that, public defenders at the very least have long been grossly under-resourced, and that's just part of the conversation and the equation. And we also have, so the manual will help you through that. And we also have pro bono lawyers who have done this work who can help advise you on how that goes as well. But that's just something that it happens. You talk to the lawyers, and more often than not, it goes really well. Okay, slide number 7, please. Okay, the next thing in the manual is that you will reach out to the prosecutor to ask them to meet with you. So, but you will do that by drafting a letter to the prosecutor. And in the cases that we've done so far, and this again may not always be the case, but in my experience, this has been the biggest chunk of the case and the biggest chunk of your time. And that is the drafting of this letter to the prosecutors. The lawyers on the panel today who are going to talk with you about this work and who have a million literally times more experience at this work than I do, will probably, I expect, tell you that this isn't always the case. But again, for the cases we've worked on, the letter is to the prosecutor is the part of the process where you put everything together, the facts and the equities that you have learned from interviewing your client, to ask the prosecutor to meet with you to talk about joining you in an agreed motion to vacate your client's original conviction. So what is in that letter? And by the way, we will have sample letters to the prosecutor on our website, and I have included one today in your materials. There will be also letters that will be embedded into the manual. So you will be able to see exactly what the universe of things are that you want to cover in your letter. The letter will contain a brief summary of the law that Sarah talked to us about last time. Factual basis, of course, that your client's circumstances fit the law. Your client was not advised, and if he had been, he would never have agreed to plead guilty, for example. Your client's life story, including his background, circumstances surrounding the crime, and your client's equities. And finally, a request that the prosecutor would meet with you to discuss entering into an agreed motion to vacate. The manual takes you step by step through the kinds of things that ought to be in the letter. And believe me, more spelled out once again than any of you will need. It's common sense. But you will be walked through it if you desire by the manual. Another thing that the manual will guide you through is you might want to, when you're drafting the letter to the prosecutor, you might want to include photos of your client with his family or other people who are important to him, or at his job with his coworkers. You might want to include, and probably will want to include, letters of support from people in your client's life. So you will work with your client to get those letters and photos and the kinds of materials that you'll find that you would like to have included. And that's all, you'll walk through that, the manual as well. So what you're doing with the prosecutor in your letter to the prosecutor is you are humanizing your client. Of course, showing that your client was not advised is the crux of the case, showing that the conviction was defective, unconstitutional, and prejudicial against your client. That is the crux of the case. But showing your client's transformation and equities will frequently be the deciding factor that helps the prosecutor decide that they're going to join you to ensure that justice is done. One thing that's important, and I'll just mention it right now, but believe me, there will be big block letters in the handoff memo, big block letters in the manual. So you'll be warned, but you will send a draft of everything that you submit to the prosecutor. Definitely a draft of everything you would ever file in court. You will send always drafts of everything to Sarah at WDA and to your client's immigration lawyer before sending. You will never send anything to anybody without running it past Sarah and your client's immigration lawyer first. But don't worry, you won't make that mistake. There are warnings all over the documentation that we give you. Okay, slide number 8, please. Negotiating with the prosecutor. Okay. After you've sent the letter, it's time to meet. Assuming, and again, we're talking about a straightforward case here, assuming that the prosecutor, after reading your letter, agrees to meet with you to talk about this, this is your chance to tell your client's story. This is where you put it all together face to face with the prosecutor, acting on behalf of your client to achieve a fair and just outcome. A lot of the time, I would say every time that we've done a case like this over the past several years, the prosecutor has also wanted to meet the client, which is a wonderful opportunity for them to meet your client and talk to them. And we usually invite family members, and it's just an opportunity for the prosecutor to see exactly what it is that they're dealing with. And I just want to remind you that prior to your intervention, your client has undoubtedly been severely unrepresented throughout their life. And this is their chance to be seen and to have the circumstances of their life and how they have intersected with the criminal legal system actually taken into consideration, actually heard and seen. So let me tell you just for a second here how it works, like technically, skipping ahead for a second. Whether the prosecution agrees to join you in your motion or not, the practical effect of vacating a conviction is that the prosecution will withdraw the conviction, putting your client and you back at square one. The state could recharge your client if it wanted to after the original conviction is vacated. So part of this negotiation that you're doing with the prosecutor is, yes, asking them to join you in an agreed motion to vacate, but then also, number two, asking the prosecutor to dismiss the charges outright, just dismiss them. Or in the alternative, if they are not willing to do that, and sometimes they aren't, usually they are not willing to dismiss, especially if the charges are fairly serious. Then in the alternative, ask the prosecutor to agree to let your client plead guilty to a charge that will satisfy the prosecution, but will not put your client at risk of deportation or other immigration consequences. So this negotiation back and forth on a immigration safe replead is something where you will be doing this in concert, working closely with Sarah at WDA and with your client's immigration lawyer. They will advise you all the way on what is a safe new charge to which to plead guilty. And it's okay to go back and forth on these negotiations that, we've gone back and forth, and I'm not going to use examples here because I'll probably get it wrong. But if your client has, an assault one and that renders them deportable, and the defense, or excuse me, the prosecutor will be like, okay, well, we'll go down to assault two. Don't take this. This isn't legal advice. I'm just thinking off the top of my head. I'll give you assault two. And you're like, okay, well, let me go check. So then you check with Sarah, and Sarah might say, no, assault two is not safe for this particular client. You can't take assault two. You have to ask for assault three. So then you go back to the prosecutor and say, will you give me assault three? We need assault three. And they'll say, okay, fine, we'll do assault three. It's like that. You're just negotiating a safe replead. Okay, so that will happen. And then you'll either get a yes or a no from the prosecutor, and you'll either get a replead or not. Then let's go with continuing along with this straightforward case, and we will go to the next slide. Sarah, thank you so much. Preparing the pleadings. So finally, once you've determined whether the prosecutor is agreeing to join you or not, you will draft the pleadings to file ahead of the hearing. And again, what I'm taking you on is a very, very straightforward, taking you through is a very, very straightforward vacate motion, where the prosecutor not only talks to you, but agrees to join you in your motion. Those are the kinds of pleadings I'm going to be talking about today. And again, great news. We have examples of every kind of pleading that you will need on our website, and the pleadings that I'm going to talk about today are included in your materials today. And they will also be exhibits to the manual. So let's talk about a situation like the first case whose pleadings I put in your materials today. The client says he wasn't advised, and the client's defense counsel admits that they didn't advise. It wasn't their practice to advise at that time that they were representing your client. So the pleadings will be, let's take a look here. Okay, the first pleading will be the motion to vacate, and it will be a short, straightforward motion with a statement of legal basis. I'm talking about 1 page, and that is included in your materials, and you can look at. The second thing that you will have is a short, straightforward proposed order for the judge to sign. Similarly, bare bones, this order is 1 page long. Along the lines of, it is ordered that the defendant's plea of guilty is hereby vacated and withdrawn. The order will have language, it will always include language that says that the order is based on a constitutional error that occurred at the trial level. You will have examples of these kinds of orders, and you will be running every pleading that you file past Sarah and your client's immigration lawyer to ensure that all of the proper language that you need is in the order. Along with the motion and the proposed order that you'll be filing, you will also be filing 2 declarations, which are also included in your materials today, and they are also exhibits to the manual, and they are on our website. The first declaration would be your client's declaration that he was not advised of the immigration consequences of his conviction, and that had he been, he never in a million years would have pled guilty. Again, samples will be available and are in your materials. The second declaration will be from your client's defense attorney, attesting to the fact that either they remember the case and they remember that they did not advise, or that simply it was not their practice at the time of your client's case to advise on the intricacies of immigration consequences of convictions and guilty pleas, as is now required. In this hypothetical, straightforward case, no disagreements over what happened, proof your client was prejudiced, agreement from the prosecutor, declarations from both your client and his former counsel. There is one more pleading to talk about, which I apologize did not make it onto the slide, and that is the new statement of defendant on plea of guilty, which you will fill out with your client ahead of the hearing. This is, of course, where after the original conviction is vacated and withdrawn, your client pleads guilty to the new immigration safe conviction that you and the prosecutor, with the assistance of Sarah at WDA and your client's immigration lawyer, negotiated and agreed upon. And there is a new statement of defendant on plea of guilty in your materials today. So in a super straightforward case, that's largely what you will need to file. And again, samples galore for your use. And finally, if we can go to the last slide, I'm way ahead of my time here. Preparing the pleadings. Number 2, we're going to talk about a second set of pleadings, an agreed motion and order where prior defense counsel did not attest to lack of advice regarding immigration consequences. So it's a case that's slightly less straightforward and ironclad. You don't have the declaration or any positive evidence whatsoever from defense counsel, no positive statement that they did not advise. The prosecution may still agree to join you in an agreed motion, but you don't have the secondhand proof that the client wasn't advised. So you will want to put a little extra oomph into these pleadings, but it will be the same general set of pleadings, a motion and order, just like the set we just talked about. But the motion, unlike the super bare bones motion we talked about a minute ago, will have much more content and meat to it, applying the facts in your client's case to the law, as well as including many of your client's equities. There will be an order similar to the one we just discussed. Again, all of these materials are, all of these sample pleadings are in your materials today and will be on our website and attached to the manual. Then you will have a declaration of the client, just like you did before, except in this declaration where the judge does not have a declaration from your client's prior counsel in front of him. Your client's declaration will take extra care to explain the circumstances of everything that happened at the trial level. For example, he only met his lawyer once, and it was in court right before he took the plea, and that the entire focus of their short conversation was just lessening the number of years or months that the client would serve so that he could get back to his family, because maybe he just had a baby or was the sole provider for his elderly mother or his spouse. You would also be careful in that declaration to not make any admissions of guilt of the underlying crime. Again, we have this declaration in your materials, and the manual will spell it out for you. We'll go through it with you. You might also, in this less straightforward scenario, wish to have another declaration. That's, if possible, it would be wonderful to have to supplement or back up that declaration of your clients. The one I have included in your materials today, because I do have one in there, is from a client's spouse. This declaration can explain, for example, that they were there when their spouse spoke with the attorney, and that there was never any mention of deportation or any immigration consequences of the plea. Oftentimes the spouse and the client will say, I was there and no one even asked if he was a citizen or not. I mean, there was literally no discussion of immigration consequences whatsoever. That spouse's declaration, as well as the declaration of the client, can also talk about the effect that the immigration consequences would have on the declarant and their family. I've included one other declaration. Let's see. Yep. And there's the new statement of defendant on plea of guilty that we talked about before. And I've also included another declaration that you might include in a case such as this, where you do not have an attestation from prior counsel that they didn't advise. And that is a declaration from a crimmigration expert, that of course being Sarah Hudson from WDA. A declaration like that, and I've, did I just say I've included it in your materials, and it's on the site. This declaration would say like what resources were available to counsel at that time and the kinds of things that the attorney should have but did not cover in his representation of your client. There will also be a lot of pleadings that the state will file in advance of the hearing. I did not provide you with those today, but those pleadings will be on the website. And we will provide those for you when we hand off a case, so that you will see exactly what the universe of documents is at the hearing that will be shuffled around from you, the client, the bailiff, etc. Regarding actually attending the hearing, so that is not, at least right now, that is not covered in the manual. That is something that we will prepare you for. We will have legal, pro bono lawyers who've done this before, and Sarah will lead you through what will happen in the hearing. The hearings are very short, particularly where they are agreed to in advance with the prosecutor. But you will get an individualized preparation, like I say, from either Sarah or other lawyers, to explain everything that will happen before you go marching in to court. I can imagine you would want to know, and you will. Each case will be different, so we'll just do that individually. I think the main thing that I want to leave you with today is that, the way this works is that we don't hand you off a client and say, good luck. You will be supported by us, by the manual, by the manual's materials, by the samples on the website, and particularly by Sarah with her legal expertise every step of the way. So that is going through a very, very straightforward vacate. I'm sure there are lawyers on this panel who will maybe snicker at how straightforward those were, but sometimes they are straightforward like that. Every one we've done has been, but I know that they won't always look like that. But that's the basic order of what you do in one of these PCR cases. Let's see, are there any questions? I see, is there anything on the chat? No, okay. Okay. Okay, so I think that is my presentation today. And if there aren't any questions, and if Neil is there, I know that there he is. Okay, great. I finished early, Neil, so.
Okay, so I could pontificate for a long time.
Oh, I hope so. I can't wait.
You know,
we all have a lot to learn. I've got my pad here to take notes.
doing CLEs on Zoom is something like I learned in the last few years, and it's such a bizarre experience. It's like doing oral arguments in front of a appellate court on Zoom. Like, you can't actually see people, you can't judge their reactions. It's very odd. So
It is very odd. And you have to be a little bit tech savvy when you're running one. I wanted to have all of the materials, but it was more than my brain could handle. You know what? One more thing before you get started. I mean, I can say it at the end too, but I still have a pipe dream of everyone being around a table and handing around the different kinds of motions and declarations and being able to look at them and ask questions in person. And I still think that we'll be able to do that. But obviously today was not that day, but maybe this is good. We get another training under our belts and learn a little bit more and then sit down and look at the materials someday. Anyway, yeah, here we are virtual. So
I want to introduce.
Sorry, Neil. Before you start, I'm just going to have to read off the first CLE code for today's training. So figured now is a great time. So I just put the form in the chat again, and the first code for today is 122010. Again, that is 122010. Okay, now Neil, I'll pass it back to you. Thank you.
Thank you. Thank you all for attending this. There is a great need for pro bono representation of people in this situation. Just by way of background, so that you know how I got into this area of the law, I'm not an immigration lawyer. I am a criminal defense lawyer. I was a public defender from 1985 to 2002. I started doing a lot of appeals and post-conviction work when I was a public defender, in addition to a trial practice. When I went into private practice in 2003, the phone was ringing off the hook from people who were in deportation proceedings because of old criminal convictions. The law actually had changed significantly in the mid to late 1990s, and a lot of crimes that were, in theory, immigration safe before 1996, all of a sudden became aggravated felonies under federal immigration law. So in the early 2000s, there was a huge need to try to figure out a way to undo cases. Unfortunately, not everyone in that situation could pay for private counsel. So it was like I was in kind of a strange position because, I was still a public defender at heart. I wanted to represent everyone. But I also had little kids. I had to charge people, and there was just no way that I could take on every single case pro bono. So there has been a need for a long time for people to represent people in this situation pro bono. So I thank you so much for that. One of the changes that has come about in the last 20 years since I started doing these cases, as really an adjunct to my post-conviction practice, is that the prosecutors and judges have pretty much changed their attitudes. So 20 years ago, it was a struggle to get an agreed order. I spent a lot of time, I litigated a lot more cases 20 years ago than I do now. There was an incredible hostility by prosecutors, even in, quote, liberal bastions like Seattle. People didn't want to sign off on these orders. And things have changed. The law has changed. This is one area of the law that has gotten better over time. Padilla came out in 2010. There was an issue federally as to whether or not Padilla is retroactive, but our state Supreme Court in around 2014, I think it was, 2013-14, held that Padilla is retroactive in the state of Washington under the state constitution. So because of those changes in the law, prosecutors have gradually changed their position. So I can't think of a case that I've actually litigated about ineffective assistance of counsel in the Padilla context in the past 8 or 9 or 10 years. I did a number of hearings, evidentiary hearings in the first decade I started doing this, and at the beginning of the second decade, but it's not something that comes up a lot now. Most prosecutors will, at least in Western Washington, will agree to the entry of orders. And that's really, really important, just in terms of this kind of change in attitude. But that doesn't mean that if you have an agreed order that it will necessarily be entered. Because apart from prosecutors, there's another party that's important, and that's the judge. Judges are independent. They don't do everything that the parties ask them to do. And there may be, on the part of the judge in a case, some reluctance just to sign off on everything presented to them. There is something called judicial independence, and that's important. It's a really good thing. It could be frustrating when you're a litigant in a case and you have an agreed order and you think, well, we have an agreed order, the equities are on our side. Why does the judge care? Why won't they just sign off on what we present to them? But judicial independence is actually a really positive trait of our legal system. And we don't want judges just blindly signing everything that's presented to them without them thinking about it and there being a reason for something. And there's also another social value to having reasons for judicial actions in the file, so that anyone coming down the road later who looks at the file, people in society, would know what took place. And they would see that there really was a constitutional violation, that there wasn't some backroom deal that was going on, that the issues are meritorious. So if there is some resistance from the bench to signing an agreed order, there's a reason for that, and that's fine. We could work around it. There may be judges with political agendas who are hostile towards immigrants. That and that I can't. I don't have a good explanation for that, for why they would be like that. But that's just my own political biases. But there are still ways to deal with that as well. Now, years ago, when the prosecutors started changing their views and started signing off on orders, I was like, great, just have like a bare bones order, a bare bones motion, send it into the judge and they'll sign it. And, that worked. But occasionally I would get resistance from the bench. And I realized that was not the way to go, that we wanted to present enough information on an agreed order to a judge so that the judge felt comfortable signing it. And that, all of the ingredients that are in the manual as to what you want in that, agreed order, that satisfies all those concerns. So moving on from judges, there are prosecutors that may not agree, even in 2022 and 2023. They may have political agendas. They may be anti-immigrant. Generally, what I've found is that the hostility is not towards immigrants, but there's a hostility towards the post-conviction process generally, that this has nothing to do with immigration, but it has to do with upsetting the finality of judgments and undoing cases that are old. So just generally about the time bar, RCW 1073-090 was adopted in 1989. The federal time bar for federal habeas relief was adopted in 1996. Before those time bars, there was no time bar. Before those statutes, there are Supreme Court cases. There's a very famous U.S. Supreme Court case from 1971 or 72, United States versus Tucker, that granted post-conviction relief for a 40-year-old conviction. there are lots of cases before the time bars were adopted of courts granting post-conviction relief decades after conviction. It was not unusual to do that. There politically in this country and in the state in the late 1980s and mid 1990s, there was a move to adopt time bars for political reasons, to cut off access to justice for people in prisons. And there are a lot of prosecutors that are very invested in that. And there are other reasons why they're invested in it. Particularly for serious cases, there's a perception publicly that people get convictions, and then years later they're going to walk out of prison before their time is up, and there's trauma to the victims' families. There's a lot of reasons why prosecutors might be, on principle, hostile towards granting post-conviction relief. And in these cases, the Padilla type cases, they're afraid that there's going to be a precedent for non-immigration related cases. They're not worried about our clients in these cases. They're worried about other people and the floodgates opening up and the whole post-conviction regimen that's been erected in the last 35 years come tumbling down. So if you understand that there are ways that you could formulate your ask letter to the prosecutors or your pleadings to take care of some of those needs, to show how exceptional this particular case is, why it's different, and why it's not going to set this precedent for undoing all convictions over the last generation. There's also different types of cases that you should be aware of. It's much easier to get post-conviction relief for a misdemeanor. So if someone was 18 years old and they went to Walmart and they shoplifted a pair of jeans, and then 20 years later they're in deportation proceedings, there's going to be a lot more sympathy towards that client than if at age 25 the person was convicted of child molestation or a robbery. And it's I get calls sometimes from immigration lawyers who want to refer cases to me for post-conviction relief, and sometimes I get like the question, well, we just need to eliminate that first-degree robbery and get them a misdemeanor. And you like, well, that's not going to be a really easy thing to do, to go to a prosecutor 20 years later and say this person had 5 first-degree robberies and a kidnapping thrown in there. I know they were they came to this country, they were the gang, and there was this horrible incident that took place in 1998. But we're talking about serious felony convictions, and they're just not going to vacate those on agreement and give someone a misdemeanor. Again, there's a precedent for non-immigration related cases that the prosecutors are going to want to deal with. There may be people with vested interests. There may be victims involved that don't want that to take place. Sometimes, though, when you figure out what actually is going on in the case, there may be situations where the victims in the case are on board with changing things. I've had cases where people have been charged and convicted of domestic violence type cases, and then things got better. The person went to domestic violence treatment, had alcohol treatment, had substance abuse treatment. They end up getting married, they have children with this person, and then 10 years later they go on a family vacation and they go to Vancouver and they get popped coming back across the border, and all of a sudden the victim in the case is looking at their loved one being taken away from them, and it's very distressing. I mean, they're the victim, and yet 10 years later they may well be on board with undoing everything and changing everything because it's to their benefit to keep their life together. So if you start getting resistance, you need to try to figure out what the resistance is based on. Where is it coming from? and then you can tailor your presentation to the prosecutor or to the judge based upon whatever you think is going to make the difference in the prosecutors or the judge's view of things. But if in fact this doesn't work and you have to file something, you have to figure out like what type of motion you're going to file and where you're going to file it. And if you don't do post-conviction cases on a general matter, I mean, this is like a whole different seminar to talk about post-conviction writs. What options are available in the state of Washington, what courts, I mean, we have writs that are filed in the trial court. You could file something in the Court of Appeals and the appellate courts. And that's like a whole different seminar to talk about. I'm sorry, I thought there was something in the chat. That's a whole different seminar to talk about post-conviction relief and post-conviction remedies generally. If you're going down that path, you do want to coordinate it with the Clemency Project. I should say that I am always available anytime for case analysis and for discussion about where to go, where to file, and how to proceed in that fashion procedurally. Sometimes there are going to be time constraints, and those time constraints drives what type of relief you want. So if the person there's a final order of deportation, the person is in custody at the Northwest Detention Center, and their country of origin are collecting travel documents to put the person on a plane, you don't want to file a personal restraint petition in the Court of Appeals that will take 2 years to resolve. Like, that's not going to be helpful. So, in that situation, you are going to want to, very quickly file something in a trial court to get a very quick hearing and to get relief very quickly. You also want to think about what the most friendly forum is. There are some judges that, are going to be sympathetic. And if you're going to have to litigate, you want to be in front of those judges. There may be judges that are not sympathetic. And so you're going to have to find a way out around that judge. Years ago, I had a case involving a municipal court in Snohomish County, where what was needed was just a 1-day reduction in the person's sentence to turn a misdemeanor theft charge from an aggravated felony under federal immigration law to a misdemeanor. And prior counsel had gone to the municipal court, the prosecutor agreed to it, but the judge wouldn't change it out of a matter of principle. And the person was in ICE custody, was going to be deported, and I had to figure out a way how to deal with this. And I ended up filing a late out of time appeal so that I could aim my emphasis at the Superior Court judge rather than the municipal court judge. There's a lot of litigation to do that, to file an out of time appeal. But ultimately, we had a more friendly forum. We had a prosecutor that agreed, and then we entered into orders in the Superior Court directing the municipal court to reduce the sentence by 1 day. And so I just circumvented the judge that had the objections. So it's worth thinking about before you file, what is it you're filing, where are you filing, and how does that tie into helping your client? Next piece is how to get around the time bar. And that's part of the narrative of the case. How and when were the adverse immigration consequences discovered? This is really important to understand because it drives the justice of your case, and it gains sympathy. So if the person was lulled into thinking that everything was okay, they were told, they were given wrong advice. They had a lawyer who said, "Oh, don't worry about it. You're not going to get deported. You'll be fine." or don't worry about it. They're not taking people back to Vietnam. Like, don't worry about it, which is just wrong advice. If you plead guilty 20 years ago and you're lulled into thinking everything's okay, and then one day, you go to Vancouver and you come back over the border, and that's when you find out, or you are trying to become a U.S. citizen, and you talk to an immigration lawyer who asks you about your criminal history, and they say, oh, well, not only can you not become a U.S. citizen with that type of conviction, but if you apply for citizenship, you're going to end up in deportation proceedings. That narrative of when you find out the adverse immigration consequences is really important to develop and understand, because it drives both the narrative of the case, in general, the equities in your client's favor, and it provides a way to try to get around the time bar, to ask for equitable tolling of the time bar or some other exception to the time bar. It's also, you need to know that, because there may be cases where the client found out about the adverse consequences years ago and did nothing. So I've had, clients that pled guilty, were sent off to the Department of Corrections for something, put into deportation proceedings, and then they get out and nothing happens. Like they're put on parole in the immigration proceedings, and they're out and nothing happens for years. And then one day, 15 years later, the government says, we want you to show up, and we're going to send you back to the country that you were born in, that you haven't lived in for 30 years. The fact in that case is that the person knew about the adverse consequences of the immigration status at the time 20 years ago, and they didn't do anything for 20 years. So you have to take that into account and figure out a way to deal with it. I've had cases where I had a client in a fairly serious, like, home invasion robbery. Was it home? I can't remember the exact details. In Pierce County, he spent time in prison, and when he found out that he was being deported, he tried to write to his lawyer to try and to find out what happened, like why he wasn't told about this. And he had preserved really dog-eared copies of the correspondence that he kept in prison, and he had 20 years later. It turned out that the lawyer, the only address that he could find for the lawyer was the lawyer working for the Attorney General's office before the lawyer went into the public defenders in Mason County, and the lawyer never got that letter. But I had evidence that he tried to do something about about what was happening to him 20 years ago, and that was very persuasive to the prosecutors to ultimately change the conviction, because this wasn't someone that knew about things and sat on it for years and didn't do anything. So once you figure out the narrative of how to get around the time bar and some of the facts connected to that, and you're going to court, you have to build your case. And a lot of the things that you're going to build when you file something in court are the same types of things that you put into your ask letter to the prosecutors. It's those facts, the narrative of your client's life, even if it doesn't bear necessarily on the legal issues involved, is really important. So if your client suffered extreme trauma as a child, they were born in a refugee camp on the Laotian border or in Thailand, they came to this country, when they were like 7, their parents were alcoholics because of the trauma that they suffered, and they were running kind of wild on the streets, and then they got themselves together over time and are completely responsible members of society now. That narrative, even if it doesn't bear on the legal issues, like how to get around the time bar, whether they were advised of the immigration consequences of the conviction, those facts are sympathetic facts, and you want to kind of develop those so that there's sympathy for your client. Like any other case, when you go to court, you want the equities to be on the side of your client, and you want to make it really, really hard for a judge to say, nope, you're going back to Laos, even though you've never lived in Laos because you were born in the refugee camp, but you're going back to Laos. Like, we don't want the judge to even think about doing that. We want the judge to be thinking, how am I going to keep this person here? And that sympathy that you build is going to be one of those factors. At prior counsel, if prior counsel is cooperative with you, and they're willing to say, I didn't advise the person of the immigration consequences. We weren't doing that back at the public defenders in 1998. That's great, and you want that person there at trial. The important thing, though, is before you start getting declarations from the counsel, and before you start putting anyone on the witness stand, you have to look at their file, because you never know what's going to be in their file. And the worst thing would be, from the standpoint of Padilla, it's good representation, but you have counsel that's mildly sympathetic to you, but when you start looking at their file, you see that there's stuff in the file about the fact that your client's not a citizen, that they had conversations with the client about immigration consequences, and that your client knew what those problems were and went ahead and pled guilty. Like, if that's in the file, like, you're going to have to figure something else out for this person. That's probably not, those are not good facts, but you don't want to just find that out after you filed everything. And one thing I have learned is that I've had lawyers that want to help their clients years later. And I once had a case where a lawyer did give me a good affidavit, and then it came out actually that he had exaggerated how ineffective he was. And it's like, okay, you should have told me something up front, because I don't want to put on perjury, and I certainly don't want to do something that's going to hurt my client down the road. And if the prosecutors find out that there is paper in the file on a key issue, it would be disastrous. So you have to look at the client's file, and you have to talk to the prior counsel, pretty thoroughly before you go down that path. I put under the evidentiary hearing part of the outline something that I'll just talk about here, which is privilege. There is an attorney-client privilege. There's a Sixth Amendment right to counsel, and when you allege ineffective assistance of counsel, there's a waiver. There's both probably an implied waiver of that confidentiality. And it's something to think about, to be aware of. Your client needs to know that they're waiving their privilege by making an allegation of ineffective assistance of counsel. And it's a limited waiver, though. It's the extent of the waiver is only is limited to the extent of the issue that you're litigating. So if you're litigating ineffective assistance of counsel with regards to advisement of immigration consequences of a conviction, that doesn't necessarily mean that the prosecutor or the judge gets to see everything in the file and ask questions about every aspect of representation of the lawyer. And this, it gets a bit dicey, because some of the strategic decisions that the lawyer and the client might have made may relate to aspects of the investigation of the case that you might not think are related to the immigration issues, but a judge may have a different opinion. And so just know that when you raise ineffective assistance of counsel, many judges and prosecutors think that every aspect of representation should come out. And your goal would be to, in some cases, it depends on the case, but in some cases, is to try to limit how much information actually comes out. Particularly if you have a prosecutor that you that if the conviction is vacated and they say, well, now you can go to trial, we're not going to give you a deal. You don't want damaging information coming out that could hurt your client down the road. So it's kind of a delicate balance of how you go down that path. Transcripts from prior court proceedings. I would never do a hearing unless I could get a transcript of what went on in court before. You shouldn't even be at this stage unless you know what took place. Many judges will give advice in court that the lawyers should have given, at least in the last 10 years, about immigration consequences, or not. Sometimes you find really good things on the record that will help your case. So, I had a case where the person, this wasn't a guilty plea, but they entered into a continuance that resulted in dismissal down at the end of the case. If they paid restitution, the case would be dismissed. And connected to that was a stipulation to guilt if the person didn't comply with the terms of the continuance. The stipulation to guilt was what would mess the person up. Even though the case was dismissed, there was still an adverse immigration consequence to that. And when I got the transcript of the hearing, everyone, the prosecutor, the judge, they all assured the defendant that by taking this deal, the defendant was protecting their ability to stay in the country, when in fact that wasn't the case. And once I was able to show that from the transcript of the proceeding, they don't have to take my client's word for it. They don't have to take the defense lawyer's word for it. It's right there in the record that everyone's talking about immigration and they're giving the person wrong information and lulling the person into a false sense of security. So you get the transcripts from the court. I do Public Records Act requests of to see what's in the prosecutor's files, because maybe the defense lawyer doesn't remember anything, or you can't find the defense lawyer because so much time has passed or their file's been destroyed. But the prosecutor's office keeps those files, and there might be email communications talking about immigration consequences. You need to know that before you go into court, rather than after, while you're in court and the prosecutor says, here are these emails from 2009, and you lose. Collateral witnesses, friends, family, the people that were present when advice was given or not given. Employers. I have cases sometimes where people can't speak English fluently. That's not their primary language. And you go back in time to 2006, for instance, and the person's English was really bad, and then you see there was no interpreter in court, or the interpreter, may not have done a good job, and so you find out, back in the day, what the client's English abilities were. Again, you're kind of reconstructing history. You're trying to figure out what happened in 2006 when the person pled guilty. Did they really understand what was going on? And there are witnesses, like in any other case, that could verify your client's story. In terms of pleadings, sometimes I've drafted pleadings and not filed them. I write up the entire motion, and I send it to the prosecutor, and I say, this is what we're going forward with. Will you join in my motion or not? And I've been told sometimes that in some jurisdictions, if you're going to be pointing the finger at someone that there's a lot of respect for in that area, that you might not put everything in detail in the court file if you could force an agreement. So it's just a question of sensitivity. But I know that there are form motions. In general, form motions are really good to look at what other people have done and to look at the content of how it's structured. But I always would take a form motion and modify it obviously for the facts of the case. And I go back and I look at the cases of anyone else's brief that I'm filing, that I'm modifying. I want to make sure that I understand what the law is and that the cases are properly cited, because the last thing you want to do is you're in court and the judge starts asking you questions about, the intricacies of some case, and you haven't looked at the case. And, what are you going to say? Like, oh, well, this is a brief from Sarah Hudson. I don't know where she is, but I didn't write it. And you don't want to do that. Ultimately, you're the one in court, and it's your obligation to your client to make sure that you understand what's going on and understand the law. And so, you take the form brief and you modify it for use in the case, and you look at the cases so that you're familiar with what's being cited to make sure that you're comfortable with it, like any other case. I would assume you wouldn't do that for some other case. Ultimately, anything that I file in any of these cases, I run by the immigration lawyer. I'm not an immigration lawyer. I make it really clear to my clients that I'm not an immigration lawyer. I have an understanding of immigration law only as it relates to post-conviction cases. And I want to make sure that whatever I'm doing doesn't cause more problems for the client. So I get nervous about form orders. I get nervous about every piece of paper that's being filed in court, and I run it by the immigration lawyer. The case is, the only reason you're there is because of the immigration consequences. And so you just want to make sure that what you're filing helps that goal and doesn't hurt that goal. In terms of the client's immigration lawyer, you will want to have an expert witness at one of these hearings. And in the old days, years ago, I would get an affidavit from my client's immigration lawyer and possibly call that person as a witness. And then I realized, somewhere, years ago, that sets up a conflict of interest. That there are issues of confidentiality between your client and the immigration lawyer. And by calling the immigration lawyer as a witness, or even getting a declaration from the immigration lawyer, that waives privilege. So I don't do that. I haven't done that for quite some time. But you are going to want someone that the court will respect and acknowledge as an expert as to what the standards are. It's easier. There's been a lot of education of judges in the last 20 years, particularly by WDA. And so what you're doing is not so unusual. But judges, they go to seminars, they know what judicial seminars, they know that these are issues, but they need to be reminded about what the standards are and how that unfolds in a particular case. And so, you get an expert on board. And I had a case once, trying to think, it was a series. I had 2 published opinions for this person in the early 2000s with an evidentiary hearing. No, it was in the early teens. It was between 2011 and 2014. And there was an set of evidentiary hearings in Superior Court in the intervening time. And we were on a very slow schedule. So basically, it was like every 3 or 4 months, we had like another afternoon of hearings, and it stretched out over a period of time. But we had my client's lawyer testify. And for some reason, my client had gone to 2 other lawyers before he ended up with the final lawyer. And the prosecutor called those 2 lawyers as witnesses, which actually turned out to be helpful for me. And then I called an expert, Jay Stansel, who used to years and years ago work for NERP, and then he ended up at the Federal Defenders as like the standards lawyer. And when the case went back up the second time to the Court of Appeals, I just remember at oral argument, Judge Schindler saying, asking me about something, and she said, "Oh, so what we're left with is that Mr. Stansel, that's what you're saying?" And I said, "Yes. That's the only evidence we have of what the standards of practice were," and I won that case. And I won it in part. I mean, I just remember that moment of acknowledgement from the judge on the Court of Appeals about my expert's testimony. So that's very important. You have to put your client on the stand, and unless you have a very unusual set of facts, and you tell the story that you've been telling the whole time, that begins with the trauma that they experienced in another country and everything that happened to them, and how they only met with their lawyer very briefly, and the lawyer didn't explain something, but that is compelling evidence, and you have to prepare your witness and work with your witness to make sure that do a sample cross to make sure that it comes out the way you want it. And then you have prior counsel. And then finally, if you lose, you need to appeal and to the higher court, because the last thing you want to do is just give up, because you might be in a bad court and an appeal will. And I had cases in one particular municipal court where the judge, every time that I've been in front of this judge, he talks a lot about his own personal history, says that he's sympathetic to immigrants, and then denies me relief. And then every time, and I can think of maybe in the last 20 years, 3 to 4 times I've had to appeal, and I've won on appeal. And then we come back and he, kind of glares at me, but you appeal because at the higher, you've created a good record, and at the higher court, there's a good chance that you'll prevail. Finally, when you're in a hearing and things are maybe going well, and the prosecutor says, "Well, let's deal this case," you have to contact the immigration lawyer and make sure that every single, whatever deal you reach is immigration friendly. And you can't even count on what your own knowledge is of the immigration law. Things change. And, within the year, let's say you've been working on the case for a year, and something may have changed in the past year. And something that you thought was immigration friendly a year ago might not be immigration friendly now, or vice versa. Something that wasn't immigration friendly might be. And so you just can't count on your own knowledge. I know that the Supreme Court said in Padilla that criminal defense lawyers are supposed to have the knowledge about immigration consequences, but it's like anything else. Like if someone comes to me with a criminal case and there's a tax issue that I know nothing about, I will associate with a tax lawyer and make sure that anything I do, I run by the tax lawyer. And it's the same thing here. Like every scrap of paper that's filed, what's attached to pieces of paper is important. Say there's a guilty plea form, and you think that it's okay because you think you're pleading guilty to a crime that you think is immigration friendly, but somehow the state's summary of the case, called a certificate of probable cause, is ultimately attached to that document. That then becomes facts for the immigration case that you can't contest. and that may contain really bad facts. So everything, anything that goes on in court, any last minute negotiations, you just have to, you can't be rushed. You can't just say, okay, we'll get this done by the end of the day. If you have to come back the next day, I've never had a problem with that. I say, Your Honor, we're in the midst of negotiations. I need to check with the immigration lawyer. And since you've been talking about immigration for the whole time, no one's going to begrudge you if you want more time, so that you don't cause a second problem while you're trying to cure the first lawyer's problem. You then commit the ineffective assistance of counsel. Like, you don't want that. You don't want someone to then have to come in a third time or another time to try to undo what you've done. So everyone I have found understands that. You know, if there's any attempt to negotiate something at the last minute, everyone's going to know that you need time to talk to an immigration lawyer to make sure that what you're doing ultimately will help the client. So that's all I have to say. I'm, happy to take whatever questions you have. And again, I thank you so much for volunteering for doing these cases. It's really, really important.
Does anybody have any questions for Neil?
I have one, like, about what percentage of the time do you get pushback from prosecutors or judges and they won't just agree to an order or the judge sign off on it?
Right now, very rare. That's a change from 10 years ago. It's harder sometimes to get answers from prosecutors now.
Mm-hmm.
So this is on the low priority list. They're old cases. It's sometimes difficult to get the answer. I haven't had, it's probably been 6 or 7 years since I've had to go to court and argue about something. So I've been getting agreed orders mostly. What I have had happen, though, in the last few years with an agreed order is the judge, this is frustrating, but the judge in their independence changes the order and strikes out something that they don't like, and then you get a signed order, and then I go into this panic mode. That's if there's not a hearing. So sometimes there's not going to be a hearing. You have an agreed order, and you send it to the court, and they just sign it. But I have had a few cases over time where the judge hasn't wanted to adopt the language that there's a constitutional violation because they haven't had a hearing. And the immigration lawyers in those cases have thought about it and said, well, the agreed motion talks about the constitutional violation. They can live with the order in court, but that's something I wouldn't just accept. I mean, I would immediately contact the immigration lawyer and say, this is the problem that we have. The judge struck something out. What does that do to us? And if you need to go back and do a motion for reconsideration, then you or appeal it, then you need to do that. But you just can't accept that. I mean, you have to think about what are the consequences of that action and how is that order going to look. But I'm not the one going to immigration court. I have to rely on the immigration lawyer's judgment because they're the ones that have to live with that order. And if they can live with it, then I'm okay. If they say, this is not acceptable, this is not going to help, then I have to figure out a way to get back into court and to change it. But that's been the biggest problem the last few years.
Yeah,
So-
and from the immigration side, the law on that has gotten even worse over the last couple of years. And the burden is even more squarely on the person seeking relief now to show that they got the post-conviction relief in accordance with, the way they have to do it. So, Louise, go ahead.
I was just gonna ask Neil if, we also haven't had any problems. We haven't done as many as you, obviously, but we've had agreement from prosecutors, but we've been, as Annie Benson used to say, justice by geography. We were always along the I-5 corridor. What about other counties? Have you done these in a lot of different counties?
I have over the last 20 years. I haven't recently.
Okay.
So recently, I seem to be more in Thurston, Pierce, and King counties.
Okay. But Pierce and Thurston, that's good.
Yeah. Well, Pierce County is always a problem.
Yes.
In general, Pierce County are
Mhm.
real sticklers on collateral attack and time bar issues. Snohomish County too, but so I have done this in other counties, but not for a while. So I don't know what's going on right now in like the Tri-Cities.
Okay. I cannot thank you enough, Neil.
Yeah,
Thank
my
you
pleasure.
so much. Kellyanne, I'm not sure if you're here. We talked about taking a little break, and I don't know do we want to ask people if they want to have a break? Or how would we like to do this? Does anybody, do you guys want to take a break? I have it a little 5 to 10 minute break in my agenda, but if you want to just keep going and end early.
Yeah, maybe we can have people do reactions and maybe have them raise their hands if they want to take a break. And
if you want to take a break, please raise your hand. And if anybody does want to take a break, we will just do that. Okay, it looks like people are just gung-ho, ready to keep going. I mean, who doesn't want to finish early on December 20th? Okay, so we are ahead of time. And so Kevin, you're next up on the agenda.
All right, thank you, Louise.
Thank
And
you.
I'll be pretty quick. I'm Kevin Hollins. I'm an attorney in the Naturalization and Citizenship Unit at the Northwest Immigrant Rights Project. Huge thank you for considering taking these cases. I'll echo Neil that there just aren't a lot of attorneys who do them, and it's really hard, especially for the clients who don't have the funds to pay for an attorney. So to have somewhere to turn to when we have these issues, it's really huge for our clients and for us and in our attempts to do the work for them. Louise largely explained with her flow chart what the process is, and I think you're all pretty familiar with that already, but I will go through a couple things, reiterate a couple of points, just so you understand a little bit more of the perspective of the people who are working at NERP. So we gather all that background information and all the different units that we have. We do removal defense, we have asylum, family services, naturalization, all different stages of the naturalization process. And then we're making these determinations. When we see that there's criminal history, we need to look for either inadmissibility grounds or deportability grounds. And so there's two different provisions of the immigration code. And some have to do with whether someone is admissible, meaning are they eligible to obtain some kind of immigration benefit or status? Are they eligible to get a green card, something like that? And then there's also separate grounds of deportability, meaning once someone has a kind of status, certain criminal grounds will say, if you get convicted of this type of offense, that you are now deportable and you could be placed in a removal proceeding. And as has already been stated by Neil, I mean, the immigration law, it's complicated, it's constantly changing, and it's often not intuitive as to what makes somebody inadmissible or deportable, and that's something you'll see. But I mean, I've had a client with a manslaughter conviction who served 8 years in prison, and he was actually not deportable for that offense, because of the mens rea of the offense and, you know, certain features of what it takes to be convicted of that offense was not deportable, but yet someone with a retail theft conviction or something that would seem certainly much less severe could be considered deportable, because that's just kind of how it works. Sometimes it's categorical. So sometimes it's just, if someone has a particular kind of offense, they are either inadmissible or deportable. Sometimes it's fact specific. And so, for instance, like if someone has a drug trafficking conviction or even arrest, you know, the government can look at that and pull up the police report and do all kinds of things like that. Categorical meaning you know, the immigration court is looking at just what was the statute of conviction. Does that meet the federal standard for being inadmissible or deportable? Either yes or no. Sometimes it's like with drug trafficking, it might be a little more of a judgment call if the government can find that if they have a reason to believe that someone was drug trafficking, that might be enough to make them inadmissible. Sometimes it's a substance offense that actually makes someone ineligible or deportable. It's, you know, the nature of it. Maybe it's called like a crime of violence, or it's a controlled substance offense, something like that. And then sometimes it's the sentence itself and sometimes in combination. So if it's a theft offense where the person received a year or more of a conviction, then that's what makes the person, you know, deportable. There are also, you know, so what we might be asking you to do sometimes is get the conviction vacated, but we also sometimes might just need you to reduce the sentence. And I think that's often easier because the state is a little more amenable to just saying it's a 364-day sentence instead of 365, right? We're dealing with legal fictions often. So, you know, immigration law says if it's a theft offense plus a year or more sentence, that makes it serious enough to be considered an aggravated felony. But in immigration law, a suspended sentence also counts as a sentence for purposes of that. So what we often have is not someone who served a year in prison. It's someone who served 2 days in jail, and then they get a sentence of 365 days, but 363 of the days are suspended. So they never actually served the other 363. It was really a 2-day sentence for criminal law purposes, but for immigration purposes, the whole thing counts, and it's a year or more sentence. So something to be aware of. And then Neil also mentioned the definition of conviction in immigration law is not the same as in criminal law. So you'll find that we might refer a case that isn't actually a conviction under criminal law, but there's 2 components to a conviction in immigration law. And was there some sort of finding or admission of guilt? And was there some sort of consequence imposed? And so you'll have these deferred prosecution agreements or you know, stipulated orders of continuance, things like that. And if they're done in an immigration safe way, there won't be any finding or admission of guilt in those. But that's not always the case. And sometimes there is. And so it's possible we could even be referring a case that isn't a conviction under criminal law, but we need it to be different than it is because it is a conviction for immigration law. Sometimes we have time pressure, sometimes we don't, and we'll be, you know, as clear about that as we can. Certainly when someone's in the midst of deportation proceedings, then there's a lot more time pressure than if someone isn't. After we fill out that intake form and send it to the Clemency Project, you'll see, you know, you'll meet with the client, you'll do all those things eventually. But one thing you'll see when we are doing our intake process and filling out that form for Louise, we are not reaching out to the defense attorney who represented the client. We're also not getting the defense attorney's file. So just as Neil said, he's not an immigration attorney. I am not a criminal defense attorney or a post-conviction relief attorney, and nor are the rest of the NERP staff. So there are certain sort of boundaries and lines that we try to draw with that. And in fact, a lot of the A lot of the attorneys on NERP staff are not licensed in Washington because you do not need to be licensed in Washington to be practicing federal immigration law. Also, about half our staff are legal advocates or accredited representatives who are not licensed attorneys, but they have a different kind of licensing that allows them to practice in certain immigration forums. And so we do need to be careful that we're not engaging in, you know, the practice of post-conviction relief law in state court, because that's not what we're licensed to do, and it's kind of a boundary that we've had to draw. So what, you know, that's one thing just to be aware of. Like, we will not have done a lot of vetting as to whether there was ineffective assistance of counsel. We're largely relying on just our clients' initial recollections of whether they were receiving ineffective, you know, what kind of assistance they received and what they can recall about what their attorney said to them. And sometimes it's just kind of clear from what happened in court that they must have received ineffective assistance. Like, they just would not have entered that kind of plea had they been given good advice. And then near the end, you know, in terms of reviewing, you know, we might have certain suggestions about what we want to see in the order. You know, Neil mentioned it's with some state courts, it can get tricky because they don't want, they'll refuse to enter certain language. And, you know, the clearer it can be for, you know, showing that there was a constitutional violation, the better for us. There may be other circumstances too, where we might try to ask that like a new guilty plea be entered backdated if possible. We might ask in certain cases where we might have to reopen an old removal case that that the record be entered in a particular way. And we also might see, you know, certain facts or admissions or you know, just notes that may get into a new statement on plea of guilty or the new probable cause statement that we would find problematic for various reasons under immigration law. Even if it solves the problem right now, like maybe we can get the conviction vacated right now, and that's it won't cause an immediate issue. Maybe the person will end up in removal proceedings sometime down the road, and then they might be, you know, trying to get some kind of discretionary relief as well. And, you know, now there might be a public document that might make it harder for them to get discretionary relief. So, so we may be able to give you a heads up about certain things, you know, that could occur later in another immigration proceeding, and make suggestions as to what you should try to add in or take out of anything that's going to be, you know, fully entered. I think that's all I was going to touch on. So I'll pass it back to you, Louise, in case unless anyone has any questions specific to.
Anybody have any questions? This is exactly what I was talking about, how, you know, what goes on at NERP that's their lane. It's different from our lane. They are immigration lawyers, specialists, and you let them, just like he's saying, and like I said during my presentation, you always run everything by Sarah at WDA and your client's immigration lawyer before you file anything, before you send anything to the prosecutor. And this isn't to make your lives harder, it's to make your lives easier, quite frankly. You don't have to worry as much about every word when you've been told that, okay, it's safe, it's okay. But yeah, they come with the immigration expertise, and you are not expected to have any of that. Okay, thank you so much, Kevin. If anybody has questions, just put it in the chat or unmute and just ask. But if not, Sarah, if you're there, we are 8 minutes ahead of time, and everybody is not very chatty today. So I've got this whole section at the end of discussion and questions, and It doesn't sound like that's going to be a big, roundtable this afternoon, so we may finish early, but I'm reintroducing Sarah Hudson from WDA. Thank you, Sarah.
Hi. So you guys have heard me talk frequently. What I have been calling myself lately is the bridge. There are other names for me that public defenders have adopted. I won't go over those with you right now. But I serve as this bridge. Not only was I an immigration attorney, I also was a criminal defense attorney, and most recently have been a criminal defense attorney. So I serve as this almost bridge translator option for everyone. So I can talk to NERP, we talk to NERP, our organization does all the time, about things we're seeing in immigration law. We keep each other up to date, how things are being charged, case law changes, and how that affects the advice that we then end up giving criminal defense attorneys about their cases. So I am very used to being the bridge, and that is in essence what I do and what I'm doing here for you. So I kind of sit with Louise, and we kind of sit in the background, not usually very much in the foreground, but then we oversee how this process goes. So I can help you put together things like a chronology if you need one based on the criminal file as well as the immigration file. I can help you go through pleadings and figure out what you want to say and how you want to say it, because Neil is exactly right. I, even myself, do not like these sample filings. They're not my favorite, and I usually do rewrite every single one every single time. Even if it's my own, I always go through and back check to make sure I haven't changed anything that made something irrelevant, because ultimately you are the person arguing this case. And I have learned from experience that if I am arguing a case and I don't know what I'm talking about, no one believes me. Selling something is really knowing it. And part of being in a courtroom is being the most prepared person there. And that's also part of the reason my job. We help you be the most prepared person in the courtroom. You are the person who the judge may look to and say, okay, I'm not familiar with this. You tell me about this. You tell me why this is relevant. You explain it. And I can tell you I've been in that role more than once. Being the person in the courtroom that the judge says, okay, explain it. And then you have to do that. And that's not to scare you. That is to tell you that we are here to support you through that process and to make you feel like you can do that. And you can go into that courtroom and be the most prepared and represent your client in the best way possible, because you are ultimately the person who is at the beginning of this process and then also kind of in the middle, because many times NERP will have handed off a client to you and then it goes back to NERP. So you'll be working very closely with Louise and I to make sure that the things that need to be there are there for both NERP's purposes and for the criminal case. And when we don't know, we have people like Neil and people like Kevin, who we all then work together. So we are in essence your team. You are the attorney of record, and you are the person who stands up in court and argues, but we have your back. That is something I absolutely want to get across, because I know sometimes when you hear all this information, you go, wow, this is way more complicated than I thought it was going to be. And you'd be right. It is complicated, but that is why you have people. I can tell you from being a public defender for years that I never got through it without my team. There's always a team of people who are helping you, whether that's other public defenders who know more than you do about a certain case, who have other arguments for you, or that's investigators, or that is social workers. That is absolutely, everyone needs a team, because that's how we get good results for clients. That's how we fulfill our duties, not only our Padilla duties, but our other duties as well as ethical attorneys providing effective assistance of counsel. That is how we do that. So I prepare the sample motions, I prepare the sample orders, but that will likely be on a case-by-case basis. Yes, there are samples included in the manual, but that very likely will have had input from whoever the immigration attorney is, my team at WDA, any sort of person who happens to be involved with a more complicated issue. We also have felony resource attorneys, we have misdemeanor resources attorneys, we have post-conviction attorneys. So we have a whole team of people that we rely on to make sure things exist in the way they need to, so that your client and your representation can be successful. I see everything. That's very scary to be saying in that particular way, but I touch and see everything and review everything. That is part of my function, not because I'm looking to rip apart your writing or tell you how things need to be. I have just seen how things sometimes can be taken and put somewhere where you didn't want them to be. And it wasn't something that you intended, but I have seen a range of different consequences come from other sorts of advocacy. And it is not always fun, but we are here to back you up. We are here to make sure that this case is what it needs to be in all stages. Because as Kevin will tell you, and any nurse lawyer will tell you, or probably any immigration lawyer will tell you, it is not easy once you get back into immigration court. We constantly have discussions about how difficult it can be in immigration in court because they don't have the same rules. They don't operate under the same standards as a criminal court does, or even a civil court. There are very different rules at play, and those rules change. And those rules can change in an instant. I think Kevin highlighted that things very much do change on a dime. And something that was safe even 2 years ago might not be. Neil touched on that, and I think that I would highlight that he is exactly right. Because sometimes things change and we don't have any notice. The advice we give 2 days ago may not be valid anymore if a new case comes down. But that is our job. That is why we are here. We are here to support you and make sure that you don't have to know those things, but that those things exist and that you do get the information that you need for your client. Negotiating with prosecutors. That is something I will help you with. They are a very interesting breed. And sometimes it isn't about negotiating with a prosecutor. Sometimes it is knowing the judge and knowing the environment that your court is in, whether or not that is the I-5 corridor or whether that is outside the I-5 corridor. I can tell you from my experience, there has been pushback on immigration safe language in these Blake issues. And Blake is a case that you may have heard of. It pretty much invalidated our state drug possession statute. And there has been pushback on those in cases outside the I-5 corridor. And that's why we're here. We, as an organization, have the ability to reach out to attorneys in the area who know the climate, who know what you'll be walking into, who know the judge, and to get some intel. Because that I always thought was really important, is knowing what you're walking into before you got there so you could be appropriately prepared. So in essence, what I am saying in a rather lengthy manner is that we're kind of your intel. We are your team, we are your backup team, and we are the people who make sure that you guys have the information you need so you can be the most prepared person in the courtroom. And that you can have the answers when someone looks at you and says, explain this to me. I think that's all I have. We're really early. I'm going to pass it back to Louise just in case.
That's awesome. I love that. Thank you. So yeah, that was, she said exactly what I hoped she would say. She's the legal brains behind the operation. You are not expected to know any of this stuff. Like Neil said, you will read the law. You will read the cases. You will know the law, of course, that you're citing, and you will write the motions based on the templates that are in the samples that I give you. But when there are intricacies and little strange things that show up, Sarah will be she just will be your guide and will give you all the legal advice that you need. So thank you, Sarah. That was awesome. So we've got, people at the front, which is Kevin and NERP. You have then SEP that organizes it and hands it to you. You do it with Sarah and the legal team at WDA with me, who helps you get all of the materials you need. And if something goes, crazy, we can call Neil. Like, we just have a whole team that'll be there to help you. So I do think that we are we're 13 minutes ahead of schedule, which I think is okay. And I wonder if anybody has questions.
Before we open it up for questions, I do have one more CLE code that I need
Great.
to read off.
Great.
So I'm going to go ahead and read that code now. Again, the link to the form is in the chat. But your second code for today is 328991. Again, the code is 328991.
Thank you so much.
Thank you.
I have a couple questions.
Yes.
So I know that when Kevin was talking about NERPs, he was saying how you don't need a Washington license to do the federal immigration work. But my understanding from the first training is that this Padilla post-conviction relief is all going to be in the state court. So do we need an active Washington license?
Yes, you will. If you're going into court, yes, you will. And I think part of why he was saying this, and Kevin, correct me if you're wrong, I think he was just mentioning that's why, you know, the lines are drawn and the lanes are clear of who does what, because certain people who work at NERP are not licensed lawyers. So yes, you guys need to be licensed. Yep. You'll be in
Okay.
state court or possibly municipal court, but that's right.
Okay, yeah, I'm just reactivating my license because I was clerking before this, so I just wanted to make sure that I had the proper licensing for it. And then, so I understand that we're doing a lot of this with either trying to get the convictions vacated or sentences reduced. And then do we also do the portion that's in the immigration courts, or do we pass that off? Okay.
That's right. So so once you get the relief in court, in state or muni court, the criminal relief, the conviction relief that you're looking for, you hand that back with the client. You give that to the client and the client goes back to Kevin or back to whoever their immigration lawyer is at NERP with vacate or whatever relief you got them in hand. And then NERP goes back and does all the immigration stuff.
Okay. And then do you know if what kind of like the timeline is for when these pro bono cases will start being handed off to us to like work on?
I would say shortly after the new year.
Okay, great.
And I don't think we have, we're not going to be handing off. We're just screening them now. So
Okay.
yeah, I mean, and we haven't finalized how we're going to do it yet, but we'll probably put out a message who wants to take a case. If you have a huge caseload in your day job, we will understand if you can't take it, but we're just trying to train you guys so that if we have a group of cases that comes down, we'll have enough people to take them.
Okay, great. Thank you.
And the number of cases that we have to refer will kind of ebb and flow depending on, the government's enforcement priorities and what's going on at the Northwest Detention Center, and things like that too. So just be aware, like there may be some pauses and sometimes where like we don't have a lot of cases to refer, but then we might have a lot of cases to refer at other times. So something to be aware of.
Remember in 2019, there was a plane leaving with a bunch of people on it. We got like 4 cases at once and we didn't have any volunteer lawyers and we did them. Jen and John did them at SCP and it was intense.
Yeah.
Is there any other questions? Those were great questions. Thank you. Okay. Okay, well, I guess that is it for the second Padilla training. I cannot thank you enough for coming. Again, I know I said this earlier, but I have a dream that someday we'll all get together and hand materials around a table, but we'll find out. We'll see, but we really look forward to seeing you all in person sometime and getting started on this work. Kellyanne, do you have any final words or shall I just wrap this up? Okay. Okay.
No,
think
no
that's-
final words for me, but thank you everyone for
Thank
coming.
you. Thank you so much. Thank you all for coming. Happy holidays, happy snow, happy everything. Thank you
Thanks,
so
everyone.
much. We'll be in touch, everybody. Thank you. Thank you, Kellyanne.
Of course, anytime. Bye, everyone.
Bye.